will be Gideon Bell, who's an associate in our commercial real estate group. And the topic of this webinar presentation today is what's all the commotion? Perspectives on pre-construction condominium cancellation. So I think it'll be very interesting. As I said, any questions, feel free to message us and we'll do our best to answer your questions. So Gideon, up to you.
Hi, Jennifer. Thanks for the introduction. Everyone can hear me okay? I assume so, Jennifer. Okay. So my name is Gideon. I am an associate at KMB Law. I assist developers and builders on residential and commercial development projects, including purchases and sales of vacant and residential property, land assembly and title conversions, securing municipal approvals and permits, and registering condos and subdivisions. As Jennifer mentioned, I'm here today to talk to you about the topic of pre-construction condo cancellations, which have received renewed industry attention in light of some of the new home industry changes caused by COVID-19. So with the market slowdown from COVID-19, some industry experts have speculated that condo cancellations will rise due to the inevitable drop in sales and financing difficulties for developers. 2020 was looking to be a hot year for new home sales, and now we're seeing delays in closings for units across the new home market, as well as developers and builders holding off and delaying launch of their projects until demand rises again and sales launches can occur. 2018 was a particularly bad year for pre-construction publicity, with two high-profile condo cancellations: Condominiums by Liberty Developments, which comprised approximately 1,200 units, and Icona condos by Gupta Group, comprising approximately 1,600 units. These two condo cancellations sounded the alarm about the risks and uncertainties that come from pre-construction condo purchases, leading to headlines such as these: condo cancellations, risk crisis of confidence, buying a pre-sale condo is a gamble, project canceled, how do you stop developers from canceling condos, buyer beware. So in both these projects, purchasers received a letter from the builder almost 2 years after entering into their agreements, advising that the project was canceled, their agreements were terminated, and that they would receive their deposits back in full, but with no further compensation from the builder. Both these condo projects have been the subject of recent litigation by purchasers. For instance, in the Cosmo condo development project, 605 purchasers brought an application in court against the developer for damages on the basis that the vendor had included a clause in the agreement that exceeded the discretion permitted by Tarion's prescribed early termination conditions. From a practical standpoint, what these purchasers were seeking were damages from the developer because they were unable to buy a similar type unit for a comparable price after the deposits were locked in the project for 2 years. The court made some valuable determinations in this case. Firstly, they decided that a court will not force a builder to go forward with a project where it has no commercially viable financing, and that would create an uneconomic project or risk bankruptcy for the builder. Secondly, a builder has a right to cancel a project on the basis of its failure to obtain satisfactory financing. This is satisfactory financing in the vendor's sole satisfaction. Thirdly, there is no law that requires a developer to compensate a purchaser for loss of investment or loss of opportunity. Purchasers' damages against a developer who cancels a condo project is the deposits paid and interest at the prescribed rate under the Condo Act. Purchasers in the Icona condos have also applied to court for damages caused by the Gupta Group's cancellation of this project. This situation is a little bit different, and this litigation is still ongoing, but purchasers are crying foul because the builder failed to disclose to the purchasers that there was a restrictive covenant on the lands that prevented the builder from constructing residential units. Furthermore, after canceling the condo, the developer was able to negotiate the removal of this restriction, allowing it to start securing approvals for another condo project on the exact same lands. In this case, all purchasers were refunded their deposit, but lost the opportunity to buy into the market while their deposits were locked in the project for almost 2 years. While condo cancellations receive a lot of media attention, these events are a lot less common than one may think. Developers do not take a decision to cancel a project lightly. There are huge pre-development costs, marketing costs, administrative costs involved in launching a project. Canceling a project is undoubtedly damaging to the developer's reputation and may risk their rating and license with Tarion for future projects. In 2019, only 12 projects were canceled, according to Tarion, comprising approximately 1,400 units. This is a fairly small proportion of the total units built in the year, which in 2019, I believe was somewhere between 60,000 and 70,000 units. So far in 2020, there have been two condo projects canceled, both actually before COVID restrictions hit, and both in Toronto for reasons of the vendor being unable to obtain satisfactory financing. There's also been a high-profile receivership of 3 Crestford development projects for 3 towers in the Yorkville region in Toronto. So why are developers permitted to cancel a pre-construction condo project? Agreements of purchase and sale for pre-construction condos are required by law to incorporate the provisions of a 12-page document called the Tarion Addendum. This document must be appended to any standard builder agreement. The provisions of the addendum supersede any other provisions provided for in the builder's agreement. Under the APS, a vendor has a unilateral right and no fault out of its obligations where it fails to satisfy any of the following early termination conditions set out in the Tarion Addendum. So number 1, failure to obtain necessary planning and zoning approval. Now there's a list of conditions set out in the Tarion Addendum, and I haven't included them all here, but it means the municipality doesn't approve the project or conditions of development make the project no longer feasible for the developer. Number 2, receipt by the vendor of confirmation that sales of condo dwelling units have exceeded a specified threshold by a specified date. This means that the builder cannot sell enough units to secure its financing or general economic feasibility. And thirdly, receipt by the vendor of confirmation that financing for the project on terms satisfactory to the vendor have been arranged by a specified date. This means that the hard and soft costs of the project have risen beyond budget projections. The vendor is not permitted to include any other early termination conditions other than the ones set out in the Tarion Addendum. And the vendor must take all commercially reasonable steps within its power to satisfy these conditions. And the developer has up to 90 days before the first tentative occupancy date to either terminate the agreement or waive these conditions. Purchasers should be cautioned that many agreements of purchase and sale also contain other conditions, which allow the vendor to terminate an agreement for purchaser's breach of contract. This could be an example of a purchaser not paying its deposit or an NSF check or failure to attend a pre-construction decor meeting. These are different than early termination conditions and allow a vendor to terminate due to the fault of purchasers. Purchasers in these cases may lose their deposit, and these breaches become subject to litigation possibly. So what is the process for a developer to cancel a project? Well, when a developer makes the decision to cancel a condo project, it must provide notice to all purchasers and advise Tarion the reasons for canceling the project. Tarion will want to ensure that the builder has exercised these early termination conditions fairly and took all commercially reasonable steps to satisfy the conditions. Where a condo project is canceled under an early termination condition, the vendor or builder must refund all deposits within 10 days of such termination, with interest from the date each amount was paid to the vendor to the date of the refund. The prescribed rate of interest to be paid to the purchaser under the Condo Act is 2 percentage points below the Bank of Canada interest rate. As the current Bank of Canada interest rate has been below 2% since 2008, purchasers in fact receive 0 interest on the termination of their agreements. Under the Condo Act, all purchaser deposits must be made payable to an escrow agent or the vendor's solicitor in trust. But many purchasers do not know that the Condo Act permits a vendor's lawyer to actually release these deposits to a developer for the use in the project if the developer obtains something called an excess condominium deposit insurance policy with a surety provider. Where the deposits are in the lawyer's trust account at the time the project is canceled, the purchaser simply makes a claim to the lawyer, who in turn issues a check for the deposits back to the purchaser. It gets a little more complicated where the vendor has already released the deposits into the project. Where the lawyer has released the deposits, in accordance with the insurance policy, the purchaser must make a claim to Tarion for the return of the protected $20,000 and a claim to the insurer for the remaining amount. Purchasers should be sensitive to the amount of deposits they pay on pre-construction condo projects and be aware that the deposits will not always be where the purchaser initially paid them. The deposit return process becomes much more complicated when a condo project or developer goes into bankruptcy. Bankruptcy of either a project or developer does not immediately cancel a project, triggering the refund of purchaser deposits. The appointed receiver, which is the individual who takes over the bankrupt's assets and distributes to creditors, will need to make a decision about how to deal with the purchasers in the project and explore options to either force the sale of the assets to pay purchasers or find another developer who will purchase the development and honor the contracts with existing purchasers. Naturally, this process can tie up purchaser deposits in a floundering project for some period of time. Purchasers are considered unsecured creditors, and that means they rank below a number of parties, including banks, mezzanine lenders, bondholders, and will only receive their entitlement from the residue of the state after the secured creditors are paid out. This situation is currently at play with 3 of Crestford's projects in Toronto, all in the Yorkville area. These projects went into receivership on March 27th after a former employee of the company blew the lid on a massive cash flow crisis in the company. In fact, this had nothing to do with COVID-19. In this case, 1,800 purchasers bought units at these projects. Substantial work had already been completed on the project, and these buildings are likely to still be finished. However, if the projects are sold to another developer, there is no obligation on the new owner to honor the existing contracts with purchasers, and that purchaser of these developments may choose to terminate the agreements and resell. Unfortunately, these purchasers have been advised to contact the receiver, and no decision has been made yet, so these purchasers are in limbo until the receiver makes a decision. So what is Tarion doing to better advise purchasers in projects of the risks of purchasing pre-construction condos? Recognizing the concerns with condo cancellations, Tarion recently made some big changes to its disclosures to further educate potential purchasers of the risks of buying in a pre-construction condo project. Firstly, all vendors must include Tarion's new buyer information sheet on the first page of any agreement of purchase and sale for a new condo where the first unit in the project is sold after January 1st, 2020. This 2-page document must be signed and acknowledged by both the purchaser and vendor and includes stern warnings about the risks of entering into a pre-construction condo. In particular, the statement, all in caps, you should be aware of the possibility that this condo may never be completed. For the most part, this new buyer information sheet replicates what's already in the mandatory Tarion addendum and includes information such as the occupancy date, early termination conditions, restrictions on title to the property that may impact the ability to build the condo, zoning status, construction status, and the advice to the purchasers that they should seek independent legal advice. The second big change that Tarion made was they made updates to their Ontario Builder Directory function on the Tarion website. This was updated to include more information about builders and vendors and projects that are canceled or under legal proceedings. For those who aren't aware, the Ontario Builder Directory is a great resource to do any research on builders or vendors, and it includes information on registration refusals and revocations of licenses, illegal building convictions, completed and in-progress developments, and canceled developments. So what can you do as a realtor to support your builder clients and customers? Your first thing is know thy builder. With the publicity of condo cancellations, purchasers are becoming more savvy and aware of the risks. Purchasers will want to know what projects the developer has done before and the reputation. Be prepared to answer those questions to put purchasers at ease that the project will, in fact, go ahead. Number 2, don't be too hasty. Use the 10-day cooling off period. Each purchaser of a condo unit has 10 days to decide whether to proceed with the purchase, or alternatively, if they don't go forward, will receive a complete refund of their deposits. Builder agreements and disclosure statements are dense documents with legal clauses of huge financial consequences. There are also clauses referring to HST rebates, delays, assignments, unanticipated adjustments. So the price that the purchaser actually pays on the front page of the agreement may not be the price that they end up having to pay on closing. Encourage the purchaser to review the agreement with a lawyer or realtor who is familiar with builder forms of agreements, who can help explain to them the risks. And number 3, a promise is a liability. Realtors are often purchasers' first point of contact when buying a pre-construction condo, as well as complaints about said condo. Promise only what you can deliver and defer questions you don't know directly to builders' representatives or the purchaser's own lawyer. The condo development process is complicated, and timelines and costs are often unpredictable at the pre-construction stage. So that concludes my presentation. I hope you enjoyed it and learned something about the commotion around condo cancellations. Now, this presentation is not meant to deter purchasers from buying pre-construction. Pre-construction is a great opportunity to get into the market for first-time home buyers and for investors to park their money with solid returns. However, there is no guarantee that a condo project will be the investment it is cracked up to be, and there are risks with financial consequences. Condo cancellations, although rare, are an unfortunate consequence of a highly expensive endeavor in a heavily regulated industry. I believe the key is enhanced disclosure and education for buyers. I think realtors and lawyers have a huge role to play in that. And that's my presentation. Thank you.
Thank you, Gideon. That was really interesting. Obviously, one of the key points of your presentation is make sure that you research the builder. So if you're a realtor watching the webinar, I'm sure you're a professional and you do all your due diligence and are able to explain to the purchasers that you have confidence in the builder, that you've done your research, that you, as far as you know, there's an ability on that builder to complete the project. Another point that I think from your presentation is, as you said, the builder's forms are very long, often many pages, and contain a lot of information. So I think it's very important that both the realtors involved in the transaction and the lawyer, because hopefully there is a lawyer that reviews the agreement on behalf of the purchaser, takes time to explain the process. Even with an educated purchaser, each builder has a different form. So I think it's important to just ensure that the purchasers have the knowledge of what the agreement contains, instead of, as you said, use the cooling off period to make sure that everything has been reviewed and understood by the purchasers. So
yeah, that's a good point, Jennifer. And there are quite a bit of developers out there who don't even use these early termination conditions. They've secured all planning approvals. They have their money. They have site plan approval. I know for lots of townhome condominiums and mid-rises, which are a little less complex than your high-rises in Toronto, they don't have any early termination conditions. So you can highlight that to the purchasers and say, hey, listen, this project is
not a risk. Yeah.
And if it doesn't go ahead, if anything happens, you're going to have damages against the developer in accordance to this Tarion addendum.
That's great. That's great. Thank you, Gideon.